Hello, NYSUT members. My name is Lena Ackerman, and I'm a NYSUT attorney. Here at the Office of General Counsel, our job is to protect you, to protect our members and our locals. One of our goals is also to educate you, to ensure you know your rights. Today, we're going to be talking about a complex, timely, and often misunderstood topic: academic freedom. Political changes and turmoil have made certain forms of teacher speech and instruction within the classroom more controversial. As a result, there are more discussions and questions regarding what academic freedom is and the rights it does and does not provide. So let's start with a basic review of free speech. Why? Because academic freedom and freedom of speech are intertwined. Given how related these topics are, we'll start with a very brief overview on the free speech rights of teachers covered in our last Know Your Rights video. First, speech does not cover only spoken and written statements. Speech refers to any act where you express yourself, including wearing shirts or pins with slogans and even making campaign donations. A teacher's speech is not protected when they are speaking in their official capacity as a teacher. Because teachers are public sector employees, their speech is considered government speech when they are on duty. The government has the right to control its own speech and can therefore control a teacher's speech to a high degree when they perform their official duties. For example, things like teaching in a classroom, coaching after-school activities, or talking with parents during conferences are all considered part of a teacher's official duties. Additionally, a teacher's speech is not protected when they act as a private citizen but discuss a personal grievance or issue with their school in a public forum. For instance, an appellate court upheld the decision of a school district to suspend a teacher who wrote a blog that was hostile to students, even though it maintained the anonymity of the teacher and students discussed. In that case, even though the speech was off-duty, the blog writing, it was clear who was writing it, and since it was hostile towards students, the speech was considered official duty speech and was not protected. But remember, a teacher's speech may be protected when they speak as a private citizen, so long as it is speech that touches on a matter of public concern. For example, a teacher goes to a rally or meeting where abortion rights are being discussed, and the teacher states their opinion or takes a side on the issue. However, and this is a big however, to determine if the speech is protected, the court will consider the competing interests of the school, parents, students, and others. For instance, if the speech severely affects the efficiency of a school's operations, then it may not be protected speech. Although there isn't always time for this, if you're concerned that the speech that you want to make may not be protected, talk to a union leader first. Adding disclaimers to your speech, such as, "This speech is my own opinion, and I do not speak on behalf of the school or the school district," can help make it clear that you're speaking as a private citizen, and that could increase the likelihood that the speech is protected. What is academic freedom? So now we move on to the question of what is academic freedom. Academic freedom refers to the ability of a teacher to choose what they teach and how they teach without outside interference. It permits the exercise of personal discretion in performing teaching duties. This discretion can include choosing what topics to cover in the classroom and how much to instruct on those topics. While academic freedom is not a right given in the Constitution, it stems from the First Amendment right to free speech. As you may have guessed, academic freedom rights are much stronger and well-defined for professors in higher education settings than for public school teachers in K-12 education. What are the academic freedom rights of professors in higher education? So let's start with higher education. Professors tend to have broad discretion over what they discuss and teach in the classroom. The Supreme Court has repeatedly affirmed the academic freedom rights of professors, as there is a high value placed on the intellectual exploration of a wide range of ideas at universities and colleges. This exploration and exposure to many ideas is seen as essential to building the future leaders of our country. Therefore, courts have affirmed the academic freedom rights of professors to cover controversial topics, including topics such as communism and the war, in the classroom. However, as we see in the news now, even the academic freedom rights of professors have limitations. Professors with professional degrees should make sure to clarify whether their speech is an opinion or an official judgment in their capacity as a professional. An appellate court recently affirmed the right of a university to terminate a professor for making what seemed like an official diagnosis of psychosis for a certain candidate for president, Donald Trump, without going through the proper procedures to make this diagnosis. Because this speech was framed as a diagnosis in their position as a psychiatrist rather than political speech or an opinion, it did not warrant the protection under academic freedom rights. Additionally, affirmative action decisions used to be considered part of the academic freedom of universities because a diverse student body was linked to the free flow of ideas. However, a recent Supreme Court decision determined that affirmative action programs are unconstitutional and therefore do not fall under academic freedom protections. This recent decision may signal the curtailing of other academic freedom rights, even at universities. While it has an important role, academic freedom is not the freedom for educators to say or do what they want, when they want, without consequences. What are academic freedom rights of public school teachers in K-12 education? Public school teachers in K-12 education have limited academic freedom rights because classroom instruction is subject to regulation by school administrators and the state. Unlike professors, public school K-12 teachers have little to no discretion over curriculum decisions. However, depending on the school district, age level, and topic, teachers may have discretion over lesson planning, how the curriculum is delivered. And we'll talk about that a little bit more. I should also remind you that academic freedom also may be limited by state law. For example, the education law in New York vests school boards with the authority and the obligation to establish the courses and curriculum taught in the district and authorizes school administrators to implement the school board policies. Curriculum decisions are viewed as vested with school boards, and courts see a legitimate community interest in having these decisions controlled by school boards rather than individual teachers of school-aged children. Courts have held that school officials must be permitted to establish and apply their curriculum in such a way as to transmit community values. So an educator's interest in maintaining academic freedom to determine the content of instruction in their classroom must be balanced against a school board's interest in establishing instructional programs. The balance of these competing interests is precisely what courts have been wrestling with for years. You may have heard that free speech rights are not automatically forfeited at the schoolhouse gate. Well, this is a concept even the current majority on the Supreme Court reiterated as recently as June 2022 in the football coach prayer case, the Bremerton case. In Bremerton, the Supreme Court also recognized the interest of school boards and administrators in regulating speech that can appear to be school-sponsored speech. According to the Supreme Court, school administrators can regulate course content so long as the regulation is reasonably related to a legitimate pedagogical concern. However, as I mentioned before, public school teachers do have some rights in terms of instruction. In other words, teachers can usually choose how to implement a given curriculum. Of course, the significant factors to consider are the student's age, maturity, and grade level, and whether the assignment relates to the curriculum and has valid pedagogical value. And given that we are in an election year, it is also important to remember that teachers should be cautious when expressing personal political views in the classroom. Courts have upheld school regulations that prohibit employees from wearing political paraphernalia, as school administration felt the demonstrations of political partisanship impinged the right to learn in an environment free of partisan political influence. Some boards of education instruct teachers to notify and obtain approval from department chairs prior to presenting controversial materials to students, even if it relates to the curriculum. The New York State School Boards Association issues model policies on a variety of topics for school boards to adopt in a manner that reflects the needs of their particular school community. One such policy is entitled Controversial Issues. Check your school board policies to see if your district has adopted this or some version of this policy. And please remember, if you have questions about the materials or lessons you want to teach, contact your union for guidance. So now that we have the lay of the land, let's talk about some fact patterns that come up frequently in your world. Let's consider this hypothetical. Suppose you're a history teacher, and in your discussion of the civil rights movement, which is part of the approved curriculum, the discussion leads to current events. You've planned your lesson, and it's in the middle of the year. So you can anticipate that this discussion may generate questions and comments regarding systemic racism, as well as lead into a discussion about current events that may raise controversial issues. So, as a rule of thumb, if you think your lesson will raise controversial issues, take whatever steps you can to be sure that your lesson plan is age-appropriate, aligned with New York State standards, in line with past practices in the school. You may even want to run this by your department head and principal. Check the board policies I mentioned earlier and your collective bargaining agreement for relevant provisions. And be sure not to advocate for a specific position on a topic. Try to engage the students to generate discussion, but you should try to not take a side. Again, the age and maturity of the students and the course level will play a major role in all of this. Another example is a high school teacher teaching a lesson about American history and discussing the relationship between slavery and the U.S. economy at that time. The teacher, as part of the lesson, directs students to participate in a demonstration, white students acting as crop holders and slave owners, and the brown and black students as slaves picking cotton. Is this an appropriate activity? Is it protected by academic freedom? No and no. This is not an appropriate activity, even though it may be related to the curriculum. And this is true regardless of which particular student demographic plays the roles of slave owners versus the slaves. This is not an activity that would be advisable. It's not an issue of academic freedom, but really a question of judgment. Educators must also consider the impact of their lessons on students and their families, and the school community at large, and they should be sensitive to generational trauma and a host of other issues. So the teacher can and should teach history accurately, but this is not an advisable exercise. If the teacher presented this to an administrator ahead of time, it would most likely be avoided and replaced with a more appropriate activity. In conclusion, academic freedom rights do not give educators unlimited ability to teach what they want and how they want. Professors generally have broad academic freedom rights and thus discretion to choose the topics they want to teach in the classroom. However, even professors should be cautious to not break with university and departmental policies and the procedures of their profession. Public school teachers in K-12 education have more limited academic freedom rights, as school boards and officials have discretion over their curriculum. As an educator, your work is vital to our communities. While teaching, controversial subjects and materials, or even those that are perceived to be controversial, may come up. Your right to engage your students in debate and discussion and choose these topics can vary. Your union is here for you and can answer questions you may have on how to approach these topics. As always, please come to your union if you have questions about this or other workplace issues.